Representative Leach.
Has been reduced to writing. Yes, sir.
Thank you,
Mr. Patterson. The clerk read the bill.
SB4 by Flores relating to the punishment for certain criminal conduct involving the smuggling of persons or the operation of a stash house, increasing criminal penalties.
The chair recognizes Mr. Guillen to explain the bill.
Thank you, Mr. Speaker. Members, SB4 squarely addresses the issue of smuggling and the operation of stash houses in our state. It targets the perpetrators of the crime, the smugglers, or the coyotes as we call them, not those that are being smuggled, but instead those who endanger both the smuggled and our fellow Texans in their pursuit of this criminal activity. This bill escalates the punishment for such acts, ensuring that Texas sends a strong message of zero tolerance against human smuggling. It provides law enforcement with the necessary tools to target and to prosecute these criminals, while also considering nuances such as family ties and the degree of cooperation with the authorities. In alignment with Governor Abbott's emergency items and his border security initiatives, SB4 is a significant step forward in fortifying our state's defenses against this type of criminal activity.
Mr. Speaker.
Ms. Niave-Corrado, for what purpose?
Does the gentleman yield?
The gentleman yield for questions.
Yes.
The gentleman yields.
Thank you, Mr. Speaker. And wanted to ask some questions of the author to make sure we have a clear understanding of this bill. This bill is not just limited to the border, correct? It has a full statewide impact. Is that right?
Right.
Okay, and it also applies to American citizens. It's not just people who are undocumented, correct?
To smugglers, yes.
So, well, it applies to any American citizen who could be arrested under this law, correct?
Who's a smuggler, yeah.
Okay, and one of the key issues that, we've discussed relating to the bill is this really evisceration of judicial discretion. Can you tell us, because we elect judges to make determinations based on the facts before them, can you tell us why you think that our judges cannot fairly determine who deserves severe punishments and who doesn't?
The thrust of this bill is to set a mandatory minimum sentence for smugglers. I mean, that's the basic idea of the bill.
Right, but you're taking away a judge's power to determine, because normally they can determine how much time that they give to a defendant who's convicted under the statute, right? So why is it that we're taking away the judge's power to determine the punishment?
Because we want to make a deterrent. We want to deter people from smuggling, and so increasing the punishment and putting a mandatory minimum is our way of doing that.
But have you put any evidence before the committee or before this body that mandatory minimums are deterrents? Because isn't it true, in fact, that the federal government has dissuaded mandatory minimums, correct?
I'm not sure about that.
Well, let me ask you this, because also we want to get an understanding of how it works. So let's say that you have a preacher or a priest who's picking up individuals for a church service, and some of them happen to be undocumented. Can you tell us how folks in this particular situation are protected from a 10-year mandatory minimum jail time? How would the preacher be protected?
So, first of all, we're not changing the definition of smuggling. And so whoever it is that would get charged for smuggling after this bill passes would also be subject to it before this bill were to pass. And so you talk about a priest potentially getting charged. Well, in order to get charged, a person, or in order to get convicted of smuggling, a person would have to commit an offense, would have to encourage or induce a person to enter or remain in this country in violation of federal law. And this is already in statute. This is not in the bill. So they'd first have to encourage or induce a person to enter or remain in this country in violation of federal law. They'd also have to conceal, harbor, or shield a person from detection. And then they would have to do those things knowingly. And so there's already a high bar, in my opinion, in statute to convict somebody or to pursue charges against somebody for smuggling.
And the part that you're referring to is subsection 2 of section 20.05 of the Penal Code, but there's also another section under 20.05 subsection 1 that says a person commits an offense if the person knowingly uses a motor vehicle, you know, and there's another section, so they could technically be charged for driving somebody. A priest could be charged for driving a van load of folks who don't have papers to mass. Is that correct?
No, I don't. Not if they had to have knowingly. If they unknowingly are transporting somebody to the store or something like that.
Let's say they're knowingly transporting a person that doesn't have papers.
They'd have to knowingly.
Let's say they're knowingly. You have a priest who is knowingly transporting somebody that they know doesn't have papers and is taking them to mass. They could be charged under the smuggling statute and get 10 years mandatory minimum jail time. Is that correct?
Well, if you're correct, they could be charged today. They could have been charged 10 years ago. They could have been charged last year for that. We're not doing that, we're not changing that in this bill.
Right, but what you are changing is the 10-year mandatory minimum. And so that's our point, that if you have a priest who's driving somebody, let me give you another example. You have an Uber driver who's picking up somebody who's undocumented and they don't know they're undocumented. Would they be convicted? Would they face a 10-year jail time?
Absolutely not. I mean, it would be very, very difficult to prosecute someone like that who didn't know what they were doing.
What if you have a good Samaritan who is prosecuting somebody or who is driving somebody, they're trying to help them, pick them up on the side of the road, and that individual doesn't have papers? Would they be facing the 10-year?
If they would, you'd have heard about the story already, because that's the statute is already there. That the language in the statute is already there. This bill doesn't change that.
But there's no language protecting good Samaritans, though, right?
Yes, there's the, let me see here. There's two sections in the code that deal with necessity. There's one that deals with necessity and another one that deals with duress. These are, again, already in the code, not touched by this bill. And so those chapters, those sections of the code would help folks like what you're talking about.
Okay, let me ask you this. What if an individual is taking somebody who they know is undocumented, doesn't have papers, to the doctor? Could they be charged? They're knowingly taking them, knowing they don't have papers. They can be charged and face a 10-year mandatory minimum jail sentence, correct?
I believe the section on necessity would keep them from being charged.
What if they're taking them to class that may not be viewed as a necessity instead of the doctor? They could face a 10-year jail time?
The way I read it, they would still need to, not only knowingly, they would also need to encourage or induce the person to enter or remain in the country, and they'd also have to conceal, harbor, or shield them. And so, yeah, if they meet all of those criteria, then yeah, they can get charged.
Okay, let me ask you this, because your bill also applies to a stash house, correct?
Right.
And a stash house, the statute refers to uses or permits another to use any real estate, building, room, tent, vehicle, boat, or other property owned by the person or under that person's control to commit these offenses. So could somebody who is renting to somebody that knows doesn't have papers be charged with the stash house and faces 10-year mandatory minimum penalty?
I think a prosecutor would have to prove that they knowingly concealed, harbored, or shielded, or that they knowingly encouraged or induced them to stay.
And if they do that, they'll face 10 years mandatory minimum jail time under your bill, correct?
If they did that, they would currently be subject to the crime of smuggling. And yes, under this bill, we would elevate the penalty.
Okay, and let me ask you this, because As you know, we don't have a mandatory minimum jail time for murder. We don't have a mandatory minimum jail time for rape. And the federal government doesn't even provide as nearly a harsh penalty. In fact, the U.S. Sentencing Commission says the federal government issues on average around a 15-month sentences for smuggling. So how the 10-year sentence seems really arbitrary. Can you tell us how you decided that it would be 10 years and not 7 years or 5 years or 3 years?
It was, first of all, it started with the governor's emergency item at the beginning of the regular session. And so that was the inspiration of it, and we drafted the bill from there.
So the governor said 10 years?
He was proposing a 10-year minimum, yes. And so we started with that idea, and we've been working with stakeholders and members of both chambers since.
So, and there's no mandatory minimum for murder, so can you tell us what the logic is in saying that this offense is worse than murder?
There's other minimum, there's plenty of other minimum, mandatory minimums in the law.
But not for murder.
I'm not sure about murder, but there is something, I think sexual assault, there's several others, I think.
Thank you.
The following amendment, the clerk read the amendment.
Amendment by Moody.
The chair recognizes Mr. Moody to explain the amendment.
Thank you, Mr. Speaker and members. This amendment would strike Section 1 of the bill, which relates to stacking sentences. I do want to talk about this, and I think it highlights some of the problems that Representative Nyave Corrado and Representative Guillen talked about in the opening of this. Not changing the underlying offenses, which may be problematic in and of themselves, but we start taking away discretion in putting in mandatory sentences, and then also in Section 1, giving the ability to stack. So stacking provisions are not normally used in criminal law. There's very narrow cases that we ask and give permission to stack. Those are intoxication cases with multiple dead bodies and certain crimes against children. The basic idea is if you do one thing and there is one criminal episode, then you get one sentence. What stacking does is allow multiple sentences for a single act that we are carving up into multiple offenses. It's really a bad way of making laws because it actually thwarts our legislative intent. We decide as a legislature what punishment is suitable for a crime. Stacking can turn what many of us may see as a low-level offense into the kinds of punishment ranges that we see for murders and rapes. But more importantly, the concept of mandatory minimums, and especially exacerbated by stacking, is something that we have been retreating from in criminal justice for years because it's wrought untold misery in our system with no real benefit. In fact, you saw changes even under the Trump administration in 2018 to these very types of policies. People are retreating from this on the left and the right side of the aisle because there is no benefit to doing this. The concept of stacking can lead to the idea of huge exposures for individuals in our court system. Innocent people that will plead guilty instead of risking trials. Criminal defense lawyers will sit with their clients and they will say, look, I think you got a good case here, but if they get you on the back end of this, you are looking at 50 years. So you are going to incentivize innocent people pleading to sentences that they shouldn't be pleading to because of the huge exposure that stacking creates. That is not a just system. This also leads to massively disproportionate sentences. Here we're talking about things like trespassing or leading officers on a foot chase. We're also jacking those up to third-degree felonies with 10-year minimums. With stacking, on top of that, we're going to put all those together. So 20, 30, 40, 50-year minimums for crimes that in other circumstances may actually be misdemeanors, thwarting our legislative intent when we set the penalty range for these offenses. And ultimately, if your goal is to nail the big-time traffickers and smugglers with these provisions, you are not going to get them. This law will not touch them. What this law will get is the 20-year-old kid who took $200 from the kind of person you don't say no to anyway to drive someone from one side of town to the other. That's who you're going to ensnare with ill-thought provisions like this. We should reject this. This provision in and of itself takes away our legislative ability to set punishment ranges, and it gives no discretion in offenses that we have determined are low-level offenses, and is a vast departure from what we do in criminal law across the board. We should be very wary of changing the philosophy on stacking for this purpose when over decades and decades and decades, only very narrow exceptions, like I said before, where there are multiple dead bodies or where there are victims that are children, where we've allowed stacking. This bill with this provision will not hit the big-time folks that you think you're going to hit. It is going to hit hard those folks that are grabbed up in this process innocently and without real education about what's going on. That's what this provision would do in reality on the front lines. Taking this out, leaving everything else in place. If we want to have mandatory minimums, if that's the track we want to go down, I don't agree with it, but if that's where we're going to go down, that's one thing. Taking it and adding stacking to it exacerbates what is already a bad policy and is a vast departure from what this body has done over decades of criminal jurisprudence.
The chair recognizes Mr. Guillen in opposition to the amendment.
Thank you, Mr. Speaker. Members, this amendment would reduce the deterrent effect of the bill by giving criminals a free ride on other crimes they commit while smuggling. The damage and harm that these criminals do to everyday Texans would go unpunished with this amendment, and we need to hold these criminals accountable for their actions. This amendment also already failed in the Senate, and I want to also point out that we currently already do this type of stacking for a bunch of crimes, including invasive visual recordings. And so I ask that you vote no on the amendment to ensure that these criminals don't get away with additional crimes while smuggling. Vote no on the amendment.
Mr. Moody, for what purpose?
Will the gentleman yield for some questions?
Will the gentleman yield for questions?
Yes.
The gentleman yields.
I guess the basic question I've got is how does this let people get away with a crime? Are they not still able to be charged under this statute without stacking provisions?
Well, yeah, because all of
So they can be charged?
All of these other crimes would have a lesser of a sentence than smuggling would, and so therefore, if they're not stacked, then they don't get additional punishment for the additional crimes.
Do you understand the concept that when crimes are committed in the same criminal episode, that we have a punishment that we've assessed for those offenses, and then judges run those consecutively because they're part of the same criminal episode, and it has not been the practice of this legislature to divest ourselves of our legislative intent to set sentencing or set punishment guidelines for offenses in which what could be a two-year offense then becomes exacerbated to 20, 30, 40, 50 years?
I would argue that there are some areas where we
very
do
narrow
that.
exceptions. Sex crimes, you mentioned some of those. Multiple dead bodies in an intoxication manslaughter. What we're talking about here...
Human trafficking?
Human trafficking. What
Which
we're
is very
talking
similar
about
to
here,
smuggling?
what we're talking about here, though, in the underlying offense of smuggling, when you talked about it earlier about encouraging or those types of actions, that you're going to then take everything within that criminal episode, not only create a mandatory minimum for the other offenses, but then permit stacking on top of that. I know you're a rock rib Republican, and have been so for years, so I know that you're aware of the Trump administration backing off on these types of policies. Are you aware of that?
I'm sorry, say that again, I'm sorry.
Are you aware?
I was distracted.
I know. Are you aware that under the Trump administration, the concept was to move away from locking in sentences and creating disproportionate impacts on sentencing? That there was an expanded legislation under the Trump administration to start peeling some of that back because of judicial economy. It's an argument that's been held on both the left and the right side of the aisle. Are you aware of that conversation in criminal justice reform?
Yes, but I think that's the next amendment that you're going to propose.
We're going to talk about this for a while.
Okay.
I guess my question still is, because when you got up there and said this would allow people to get away with crimes, how does someone get away with a crime if they are convicted and sentenced to time in prison for an offense? Because that could still happen without stacking.
In the case that you're describing, they would commit the crime of smuggling, they would get punished for the crime of smuggling, they would commit other crimes, and then they would be served continuously or consecutively, I'm sorry, and so therefore not get an additional penalty for those additional crimes. And that's what we're addressing in the bill.
Do you think being convicted of a crime is not a penalty?
Obviously, it's a penalty for the crime that you're being punished for. But if you don't have to serve any time for the additional crimes, then you're not paying for those additional crimes. You're only paying for one crime.
No, but when you're booked on offenses like this, you are serving all of that time. Time is time. And when you do the crime, you got to do the time. Absolutely. The point is, when we legislatively state that an offense should be subject to X penalty, and then we lob on top of it a stacking provision, like I said, which is outside the norm of what we do in criminal law when we're talking about the same criminal episode. When we're talking about the same criminal episode.
It's not outside of what we do entirely.
It is way outside the norm of what we do. There are very narrow exceptions in which we have changed that.
And we're already doing it for human smuggling, which is very similar to smuggling. I mean, for human trafficking, rather. I'm sorry, human trafficking.
Do you think it's fair for a 20-year-old kid that took $200 to drive someone from one end of town to the other to have offenses stacked on top of them?
If he doesn't know what he's being paid $200 for, if he thinks it's just being paid $200 to drive from point A to point B, and he doesn't know that he's trafficking someone because they're stuck somewhere in the truck or in the trunk, I don't think that he's going to be able to be prosecuted. Well,
there was a witness that came to testify when this bill was up in committee, and that witness said he was prosecuted for that. He was prosecuted for that. And by the work of his lawyer, he was able to get a different sentence. However, when you do these things and you create such a exposure for clients, and I know you don't practice in the legal world, but when we're advising clients, even if they have a decent case, the conversation is, we think you have a decent case, but the exposure has now been exacerbated to such an extent that the risk is way more than I can advise a client to take. So that young man in that situation who had his lawyer be able to talk to someone and walk them back from that charge is going to be in a completely different scenario now if this structure is in place, because the risk calculation is very different when you have stacking sitting in front of you. Do you think that is a fair system to put in place?
What we're trying to do with this bill is deter smuggling. We're upping the mandatory minimums. We're throwing the book at them. We're trying to deter smuggling. I understand your position, and I just have to agree to disagree.
Do you have some statistics on the deterrence effect of these laws?
There was a 2022 Federal Sentencing Commission study that found that for federal offenders that were released, the odds of recidivism were lower for federal offenders sentenced to more than 60 months rather than those that were sentenced to less.
Look, the studies that we've seen in this state on the deterrence effect of what we do, because there is no deterrence effect for these people like I just described, where they are in a pinch and are offered money to drive someone from one place to the next, and all of a sudden they are wrapped into a situation in which they are staring at 20, 30, 40, 50 years for something that this legislature, in some instances, has determined to be a misdemeanor, be that trespass or something else. Because it's not just the smuggling that you can stack on top of this. It's everything that is part of that criminal episode. So you're exacerbating all of that under that. Do you understand that's what this does?
The entire thrust of the bill is to elevate the mandatory minimums, to elevate the punishment, to deter this kind of criminal activity.
And my proposition to you is you can do all of that without creating a grave injustice and a bad situation for a lot of cases around the state where people are going to be wrapped up in a very high sentencing range, people that may actually be innocent of those crimes, but are going to end up pleading guilty because they know that the risk of going to trial is now sitting at 50 when that was nothing near what it would have been under the prior law. So when you say that someone is going to get away with the crime, I put it to you, someone is going to get convicted of a crime that they didn't commit. That's what happens when we do these one-size-fits-all, ill-advised policies. This is what happens. It's happening around our state right now under current laws and in the country. And there's been a retreat generally, even under Republican administrations, to get away from this type of practice.
If you're right, you should propose a bill to change the definition of smuggling.
I have been fighting that battle since 2013, Mr. Guillen. Thank you.
Gentleman's time has expired. The chair recognizes Mr. Moody to close on the amendment.
Thank you, Mr. Speaker and members. We often say that we need to be smarter on justice issues, and what looks tough on paper doesn't always equate to a tougher result in the real world. The bad guys that you think you're going to grab with this are never going to be grabbed by this. They're not. The people you're going to ensnare in this are like that kid that came and testified in committee. He's going to be looking at something much more serious, and he's going to end up pleading to a case that he has no business pleading to. And that person is then going to go into the prison system and likely find himself in and out of there for the rest of his life, because that is the way the system works. That is the net result of encouraging policies like this. And I'm not just creating this out of whole cloth. This is the story not just in Texas, but across this country. It is why both Republicans and Democrats have moved away from this type of one-size-fits-all approach, because it does not do justice in reality. It sounds tough, but what it is unfair and unjust, and is going to lead to bad results that no one in this chamber will be proud of. I move adoption.
The question occurs on the adoption of the amendment. This record vote. The clerk ring the bell. Show Mr. Moody voting aye. Mr. Guillen voting nay. Show Ms. Flores voting aye. Show Ms. Click voting nay. Have all members voted? All members voted. There being 59 ayes and 85 nays, the amendment fails to adopt. The following amendment, the clerk read the amendment.
Amendment by Flores.
The chair recognizes Ms. Flores to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment would bring this bill to actually to its full intent, because the intent of the SB4 is to punish those who engage in human smuggling operations. But this bill, though, is drafted way too broadly, and it threatens to ensnare Texans who are just living out their everyday lives, attempting to be good friends, family members, compassionate community members, and particularly those who are doing our Lord Jesus would want them to do. So what does this amendment do? What it does is it moves the language of the intent of gaining pecuniary gain, financial gain from transporting folks if they knowingly know that they are doing it to smuggle them. So what it does, basically, this amendment makes pecuniary, the intent to obtain pecuniary benefit, a basic element of the crime. Therefore, it would capture anybody, smugglers, who are intending to make money out of transporting humans, people who they knowingly know they're not supposed to be, or that they're trying to smuggle into the country. So we want to make sure that, as the previous amendment said, we don't want to make this an overly broad bill. We want to make sure that innocent folks are not captured in the net, and we want to make sure, but we are not taking away the intent of the bill. We're basically saying anybody who intends to make financial gain and not only does so and transports somebody, then they will be found guilty of that offense. What it does do is it moves that definition away from the enhancement elements, but it does not remove it as an element of the crime. So we just want to make sure that if you have a priest who's taking somebody to church is not necessarily caught, a family member who is driving somebody to an appointment is taking somebody and they're not doing it for financial gain, that they are not entrapped in this with this bill. So members, it's an easy thing. I hope it's acceptable to the author, but anyway, I move adoption of this amendment.
The chair recognizes Mr. Guillen in opposition to the amendment.
Thank you, Mr. Speaker. Members, this amendment significantly alters the burden of proof on the state against criminals committing egregious crimes. Cartels do not write payment receipts or issue W-2s to smugglers who do their dirty work. This would make smuggling very difficult to prosecute. I therefore ask you that you vote no on the amendment. And this amendment also already failed in the Senate. I ask you to vote no on the amendment.
The chair recognizes Ms. Flores to close on the amendment.
It would not remove smugglers from being prosecuted. It would just make sure that those folks who do not have the intent to be smuggling and are not getting a financial gain by transporting people to and from places that they need to be. So this bill, in fact, makes it an offense if you knowingly and intentionally make money in transporting a person, and it lays out all the elements of in a motor vehicle, aircraft, watercraft, anywhere, or you're attempting to conceal or to flee from a person or a peace officer. So this bill really does not help smugglers. This just helps innocent people who are trying to be good citizens and good friends and family members. So I ask you to please vote for this amendment.
The question occurs on the adoption of the amendment. The record vote, the clerk ring the bell. Mr. Guillen voting nay, Ms. Flores voting aye. Mr. Kane voting nay. Have all members voted? Have all members voted? There being 60 ayes and 85 nays, the amendment fails to adopt. The following amendment, the clerk read the amendment.
Amendment by Perez.
The chair recognizes Ms. Perez to explain the amendment.
Thank you, Mr. Speaker. Members, the current version of SB4 creates a new mandatory minimum sentence for smuggling of 10 years, but also provides a downgrade that reduces that sentence to 5 years if a person is related to the undocumented person within 3 degrees of contiguity or affinity. Third degree includes aunts, uncles, nieces, nephews, great-grandparents, and great-grandchildren. The proposed amendment recognizes the close-knit nature of the diverse communities of our state and expands the downgrade mentioned above from the third to the fourth degree. Fourth degree would include great-grandparents, great-aunts, uncles, first cousins, and grandnieces and nephews. The most notable group that would be protected under this amendment would be first cousins. Latinx communities are close-knit, as are communities of other cultures and ethnic groups that call Texas home. Many Latinx families rely heavily on extended family members, including cousins, uncles, and aunts. This means that first cousins often act more like a sibling, for instance, relying on each other for rides to and from work and to medical appointments. And with that, I move adoption.
The chair recognizes Mr. Guillen in opposition to the amendment.
Thank you, Mr. Speaker. Members, this amendment adds fourth-degree family members to the modulation section or the sentence reduction section of this bill. The bar to prosecute smuggling is already set high, in my humble opinion, as you'd have to prove that they encouraged or induced to enter or remain in the country, that they concealed, harbored, or shielded the person from detection, and that they knowingly did it. We also already have the modulation in the bill for third-degree family members, and so therefore, I ask that you vote no on the amendment.
The chair recognizes Ms. Perez to close on the amendment.
Thank you, Mr. Speaker. This is a very simple amendment. All it does is allow for cousins to be included in that downgrade to the mandatory minimum. This amendment will also allow our law enforcement officers to focus not on families, but on real perpetrators of human smuggling.
The question occurs on adoption of the amendment. This is a record vote. The clerk ring the bell. Show Ms. Perez voting aye, Mr. Guillen voting nay. Show Mr. Bojani voting aye. Mr. Jatan voting nay. Have all members voted? All members voted. There being 59 ayes and 86 nays, the amendment fails to adopt. The following amendment, the clerk read the amendment.
Amendment by Hernandez.
The chair recognizes Mr. Hernandez to explain the amendment.
Thank you, Mr. Speaker and members. My amendment would extend the affirmative defense for prosecution of this offense, smuggling, to individuals related within the third degree of consanguinity or affinity. The amendment would also extend the affirmative defense at the punishment stage for individuals related within the fourth degree of consanguinity or affinity, which includes cousins. Current statute already includes an affirmative defense for individuals related within the second degree, like brothers, sisters, grandparents, and grandchildren. However, many of us have large families and are very close. In the Latino community specifically, we tend to be tight-knit and often live in multi-generational homes with aunts, uncles, nieces, and nephews. We also tend to be close to our cousins and often refer to them as our primos hermanos, which roughly translate to siblings, cousins, to demonstrate the strong familial ties. Unfortunately, these relationships would be criminalized under Senate Bill 4. An aunt could receive a 5-year term of imprisonment for taking her undocumented niece to school or church or a soccer game. This bill will also give a 10-year term of imprisonment for cousins in mixed immigration statuses that were in the same home or were carpooling together. That is not smuggling. That is not justice. And we should not be criminalizing our communities for coming together and being close-knit. My amendment would extend the affirmative defense to prosecution of smuggling to individuals related within third degree, and would also reduce the punishment to 5 years for imprisonment for individuals related within the fourth degree of consanguinity or affinity. This would allow our communities to live or carpool with undocumented family members like cousins without fear of a mandatory 10-year term of imprisonment. I move adoption.
Ms. Johnson Harris, what purpose?
Yes. Will the gentlelady yield for questions?
Will the gentlelady yield for questions?
I do.
She yields.
Thank you, Vice Chair Hernandez. I just kind of want to clarify because the room is loud. I know we're at that stage.
Members, please take your conversations outside the rail.
Unfortunately, we may be at that stage where we're getting into some hyper-partisan votes. So I just want to ask that you clarify this when we talk about third degree versus fourth degree. So what you're saying is the bill already allows an affirmative defense for certain family members within the third degree, second degree, and all you're doing is expanding that out one layer to acknowledge those, again, family members. Just like we're talking about siblings, here we're talking about cousins. But you're not expanding this out to unknown, you're expanding this into the family circle. So would you again just clarify when we talk about this degree of consanguinity, just as we did last session in protecting elected officials and their relatives, why is it so important that we just expand this if people want to get this passed into law?
Thank you for that question. And it's important, especially in the Latino community. We tend to have large families and are very close-knit. We come together for quinceañeras, for bautizos, for large family gatherings. And we don't go around asking, are you documented, undocumented, tienes papeles, no tienes papeles? No. And so this bill would criminalize our family and our ability to come together and to be able to have that close-knit relationship. The second degree of consanguinity includes grandchildren, brothers, sisters, and grandparents. It does not include nieces or nephews or aunts or uncles. That is a family gathering when we come together for special events. And so that this bill would be criminalizing our families for doing that.
So again, all your amendment is doing is taking the already recognition of Chairman Guillen's bill that nucleus of family is not going to be caught up in criminal law, and it's just recognizing that in many communities, that close-knit family expands to our cousins, nieces, and nephews.
Exactly. Protecting the small families and the large families, not just discriminating between the sizes of families or your relationship with different family members.
So what if I wanted to claim my play cousin fits into the circle? Would your amendment allow me to just say, hey, she's my play cousin, we're that close, you can't go after her?
No, it would not. It would not apply to that situation, just like, unfortunately, it wouldn't apply to my godmother, my godparents, because they are not within that degree of consanguinity, even though that is a very important role. Whenever you select a godparent for your child, it's very important, and you would want that to be included as well, but unfortunately, that's not included within these degrees of consanguinity or affinity.
So again, a perpetrator could not manipulate a situation or a description of family entity to make them fit into your amendment. Your amendment just recognizes the necessary expansion of the existing bill.
That is correct.
Would you also go through with us again as a lawyer on an affirmative defense? So you're not saying that the police officers have to walk away. An affirmative defense still means people can get filed on and you get them in the court process, and then you just legitimately have to prove this familial connection that you are, again, just correcting to acknowledge the existence of our social family unit and how we actually get around together, not just with our grandparents and our parents.
That is correct. It wouldn't be on the spot someone saying, hey, this is my cousin, everything is okay. No, it would be an affirmative defense after they've already been in the procedure, in the prosecutorial.
After they've already been arrested, after they've already been charged, after maybe they've already gone to court. We're just saying that this acknowledges that you can still do the immediate intervention you say you're seeking, but we don't convict family members in this circumstance.
Absolutely. We do not convict family members for being close-knit and spending time together.
Thank you for the amendment.
Thank you.
The chair recognizes Mr. Guillen in opposition to the amendment.
Thank you, Mr. Speaker. Members, this amendment would expand the affirmative defense to prosecution for the crime of smuggling to family members in the third degree of consanguinity or affinity, and it would shift the modulation of the penalty for smuggling from a third degree to the fourth degree of family members. It's very similar, or half of it is similar to the previous amendment that we just voted on. We already have a reduction in the bill for third degree family members. And I'd also point out that in my humble opinion, the bar to prosecute smuggling is already set high, as you'd have to prove that they encouraged or induced, that they concealed, harbored, or shielded, and that they knowingly did it. We therefore, we already also have protections in statute and in the bill for family that is within the first and second degree of consanguinity and affinity, and so I ask you to vote no on the amendment.
Mr. Speaker.
Ms. Johnson-Harris,
Will the gentleman yield for questions?
The gentleman yield for questions.
Yes.
The gentleman yields.
Chairman Guillen, we all know that today is going to be an incredibly emotional day, potentially, right? When we talk about these issues, for example, this amendment that Vice Chair Hernandez talks about, she can feel it because she knows how this is going to impact her family, right? My in-laws, the appearance of being brown means that you might be subjected to new laws being passed in the state of Texas, correct?
I would point out that we're not changing the definition of smuggling. We're just elevating the penalty. And so if you did something that would,
and you know,
currently or before this bill were to pass, if you were to do something that would get you charged and convicted, that doesn't change under this bill.
But we are changing laws that have already existed, correct? You're doing something different, right?
Yeah, we're elevating the penalty.
Okay. Are you aware that in the last hour, a story has broken on Texas Tribune about some of the folks that are trying to push the House and the Senate to pass some of these changes to our laws?
No, I'm not aware.
Are you aware that the Texas Tribune is reporting that leader of anti-immigration group Texans for Strong Borders also runs an anonymous hate-filled social media account, which is again connected to Nick Fuentes?
No.
You weren't aware that a prominent anonymous figure in Nick Fuentes' white supremacist movement is also the leader of Texans for Strong Borders, a well-connected group that has recently emerged as an influential voice of the Texas GOP and pushed lawmakers to crack down on legal and illegal immigration.
Members, please confine your remarks to the amendment before the House.
I'm not sure what this has to do with the bill.
Because your colleague standing next to you, regardless of our partisan divide, has a very legitimate amendment to make sure that relatives of folks are not wrongfully incarcerated under the idea of, quote, smuggling.
So what's the question? I'm sorry.
Are you open to the amendment being offered by your colleague who you know knows how detrimental this will be to many Texans? That the policy does matter. And that if it wasn't going to do something different, you wouldn't be pushing to change the law. So if people weren't going to be affected, you wouldn't be here.
We have language in the bill that modulates the third-degree family members. And of course, we have language in statute that gives affirmative defense to prosecution for family members in the first and second degree. And so we are doing many of the things that y'all are calling for, but we're also trying to be tough, and we're trying to send a message that smuggling's not going to be tolerated anymore.
So if it works for my sibling, why can't I be protected from my cousin?
If it works for who? I'm sorry?
If you don't want my sister prosecuted, then why do you want my cousin prosecuted?
That's already in the statute, and we're not changing that in the bill.
I don't think that your colleague agrees. So if it's already in statute, what's wrong with accepting her amendment that just confirms it would be in statute?
Again, we believe we already have enough protections in the bill for family members, in the statute and in the bill for family members. And we're trying, the goal of the bill is to deter smuggling in Texas. And we believe that this will achieve that.
So again, if you're in communication and saying you're already doing it, would you be willing to accept Vice Chair Hernandez's amendment?
No. We have protections in the law and protections in the bill already for family members.
Okay, real quick.
Mr. Kane, for what purpose?
Question for the author.
The gentleman yield for a question.
Mr. Again, I heard a few questions asked by Representative Van Johnson. Just kind of clarify, did you visit with that loser named Chris Russo to draft this bill? Probably not.
With who?
Some guy named Chris Russo. She was asking about people with Texans for strong borders. They didn't write this bill, right?
Members, let's confine our remarks to the members.
I just want to clarify things.
No, absolutely not.
Right. Border security is the #1 issue in Texas. Is that correct?
I would think so. Yes.
So? Great. It's a great bill. That's all.
Vote no on the amendment, please.
The chair recognizes Ms. Hernandez to close on the amendment.
Thank you, Mr. Speaker and members. And I appreciate that Mr. Guillen recognizes the importance of family members and including that in the current law and his proposed legislation. I'm just saying our families aren't that small. The only thing that's included right now for an affirmative defense or in the prosecution in the sentencing stage is first degree and second degree, which would be children, parents, brothers, sisters, grandparents, grandchildren. What's not included would be nieces, nephews, aunts, uncles, great-grandparents, and cousins. So I don't know how many of you all get together with your family, but we have family gatherings that includes those degrees of consanguinity. So I'm just asking, please do not criminalize my family.
Mr. Root, for what purpose?
Mr. Speaker, will the lady yield for questions?
Will the lady yield for questions?
I do.
She yields.
Representative Hernandez, part of the reason that you're putting this amendment is that the originating legislation, the original smuggling statute, is a statute that is written with very vague language. Would that be fair?
I believe so, yes.
And the language could cover a little, or it can be interpreted to cover a lot of stuff. Would that be fair?
Yes.
So even someone who's just riding in a car, right? If an officer says, oh, we think that they were trying to evade us because they turned left when they should have turned right, that could be interpreted as smuggling, potentially.
It could, yes.
Right? And the point of your amendment is to say, hey, if this is a family member, somebody that is related by blood, that we should not go that hard on them, because as it happens with the Latino families, as it happens with Asian families, as it happens with a lot of families, we have large extended families, and we take care of each other, and we give each other rides, and we help each other go to school, and we help each other go to work, and we do all these things. Is that fair?
Yes.
And the current bill, as it is in its current form, only covers to the third degree of blood relation. Is that correct?
That is correct.
Okay. So second degree would get us brothers, would get us moms and dads, right? And then third degree would only get us grandparents, but would not touch anybody outside of our immediate family, correct?
Correct.
And your amendment to add fourth degree only adds in people related by blood who are your brother's kids, your nephews, your nieces, and people like that, right?
Right. The fourth degree would include your cousins, people that you grow up playing with when they come over to visit you.
These are your family members by blood.
That is correct.
And your amendment doesn't even excuse them from the charge, does it?
No, this is only in the punishment stage of the trial.
This is only to say 5 years instead of 10 years.
Unfortunately, yes, it's not even saying
and even
that
5 years in itself is extreme compared to what the feds do.
That is correct, for having a gathering with your cousins.
So your amendment only seeks to protect people that you grew up with, that you live with, that you play with, that you spend family outings with, that you travel with.
That is correct.
Thank you.
I move adoption.
The question occurs on the adoption of the amendment. There's a record vote. The clerk ring the bell. Show Ms. Hernandez voting aye, Mr. Anchia voting aye, Mr. Guillen voting nay, Ms. Johnson-Harris voting aye, Ms. Garcia voting aye, Ms. Aguirre voting aye. Have all members voted? All members voting? There being 61 ayes and 85 nays, the amendment fails to adopt. The following amendment, the clerk read the amendment.
Amendment by Garcia.
The chair recognizes Ms. Garcia to explain the amendment.
Thank you, Mr. Speaker. Colleagues, 1 out of every 8 Texans who have been arrested for smuggling under Operation Lone Star are between the ages of 18 and 19. And according to an analysis by the Human Rights Watch, at least a dozen of teenagers as young as 14 have been detained for the offense over the last 2 years. To serve in this House for me is something that I never thought would be possible. And the reason for that is because as a young girl, I come from a very impacted community. A community where my very existence was viewed as an issue, a problem at home. Sometimes I found love and acceptance from older people in the streets. Sometimes I found a place to sleep at night from older people in the streets. Sometimes I found food from older people in the streets. Sometimes I received my love from older people in the streets. But that love didn't come without consequence, because I was expected to do things sometimes that I would not have done had it not been for those people who convinced me. I'm asking that we please put into consideration the demographic of people that are used to be smugglers. The demographic of people that are used to be smugglers, because rest assured, it's not the bad guy that's going to get caught human trafficking. It's not the boogeyman that's going to get caught human trafficking. It's the children that they use to do their biddings for them. Am I okay? Oh, I'm too close? Sorry. You can't hear me? How about now? No?
Mr. Sherman, for what purpose?
I'm muffled?
Mr. Speaker, does the lady gentleman yield for questions?
Does the lady yield for questions?
Yes, I do.
She yields
lady
for
gentlewoman.
Thank you.
Representative Garcia, why are you offering this amendment this morning or this afternoon now?
Well, I'm offering this specific amendment, sir, because with the increased penalties that that we're trying to impose right now, I would like for there to be an exception for children and young adults under the age of 20. Why? Because they're not the masterminds. They are simply pawns who are used to do the biddings of the bad guy. And I know this to be a fact because as a veteran, as an Iraq war veteran, when we do training overseas, we are taught that the number one person we have to look out for are the children. And why is that? Why as a mother, when I served in Iraq, I had to be cognizant and afraid of the kids? Why did I have to do that? Because the bad guys use children to do their bidding. I'm asking that we please file an exemption, allow for an exemption, so that these kids don't spend 10 years of their lives in prison for a nonviolent offense. Nonviolent offense. A 15-year-old who is doing the bidding of the bad guys. And as you heard Representative Moody state, you can't just say no. They tell you get in a car, go pick somebody up. You tell them no, you risk losing your life.
So, Representative Garcia, you stand in the hope and understanding that Representative Guillen would be open to you providing this provision, this amendment to protect the children?
Yes, sir, absolutely. Because one thing that I know for a fact, I know that everybody in here loves Texas. I know that for a fact. And what I do know is that we do have a crisis. Rest assured, we have a major crisis happening on the Texas borders. There's also laws in place already to address those issues. And if the laws have not caught the bad guys yet, then what makes us think that adding more time is going to make any difference? It's really not. All it's going to do is ensure that children end up incarcerated in the most formative times of their lives. It's ensuring that by the time that they serve their time and are released, they are already middle-aged people who won't know how to navigate the current world. They're used as pawns. And I know that is not the intention of Representative Guillen. It's not his intention to criminalize our children who are being used as pawns on the border. And that is the reason why I'm asking, I'm begging, I'm appealing to all of you to please accept my amendment allowing for an exemption when it comes to those under the age of 20.
So this is for those under the age of 20. That's the only exclusion that you're asking?
Yes, sir, absolutely. And it's not saying that there's not an accountability for people who are caught doing crimes that have victims involved. Any violent crime, there's already statutes in place. These are specifically non-violent crimes perpetrated by children that I'm asking and pleading for an exemption on.
Thank you, Representative. I hope that Representative Guillen is open to your amendment.
Thank you, sir. Sorry, I get a little passionate. Forgive me. This amendment would intend for our youngest members to be allowed to live their lives. A lot of times, the bad guys are victimizing our kids. They're going on social media. They're telling them all this great stuff that they'll provide for them. And that's what's driving these children to be a part of these scenarios. They're unwilling participants in a much larger crime. And with that, Mr. Speaker, I move adoption for this amendment.
The chair recognizes Mr. Guillen in opposition to the amendment.
Thank you, Mr. Speaker. Members, this amendment creates an arbitrary break, or gives an arbitrary break to individuals under 20 years of age. We already have a reduction for family members in the bill, and it's important to point out that the bar to prosecute smuggling is already set high, as you have to prove that you encouraged or induced, that you concealed, you harbored, or you shielded, and that you knowingly did it. Colonel Wilson just came up to me and reminded me that we send, that many of the soldiers that he had in his unit were under 20 years of age. And if we can send them off to war, then they should be subject to the criminal penalties that we have as well.
Ms. Garcia, for what purpose?
May the gentleman yield for a few questions?
Would the gentleman yield for questions?
Yes.
Thank you so much, Representative Guillen, for mentioning our soldiers that we send to war who are under the age of 20. These individuals, I was one of them, actually. I was 16 years old when I signed up for delayed enlistment. And one thing that was beautiful about that is that I knew I can trust the people that were supporting me. I knew that I can trust my chain of command. I knew that with my amount of time and basic training teaching me how to navigate as a airman overseas during these issues, I knew that with my continuing education, with my firearms training, as well as with the extensive legal training we get as being members, I know with all of that, we are better prepared. And we are prepared, and we are also volunteers of war. What I'm asking for here are for children who are not volunteers. And my question, sir, is, are there any provisions or safeguards within this bill to protect children?
If they don't knowingly do it, if they don't know that they're breaking the law, then I would argue that yes. For example, let's say somebody pays them to move a vehicle from point A to point B, and they don't know what is in the vehicle, and it's a situation that they wouldn't be able, that they might not know what is in the vehicle. Then I would argue that the current statute would not allow them to be prosecuted, or would make it very, very difficult for them to be prosecuted.
Representative, do you believe that a 13-year-old who gets into a car and drives from point A to point B and knows that there might be somebody in his car undocumented deserves to serve 10 years of his life in prison simply for driving a car from point A to point B with a passenger?
The purpose of this bill is to deter this kind of criminal activity, to deter smuggling. And we believe that by increasing the penalty, by putting a mandatory minimum, that we're going to deter that kind of criminal activity. And so I believe that it's important. I think the majority of Texans believe it's important, and that's what we're doing in this bill.
Sir, do you believe that a 13-year-old who's incarcerated for 10 years is going to affect the grand scheme of an operation of the cartels or the bigger picture boogeyman that we are describing here today? Do you believe that that 13-year-old doing 10 years in prison is going to change the operations at all?
I believe that when folks get sentenced, when smugglers get sentenced to 10 years in prison, that it will be a deterrence, yes.
Unfortunately, sir, I do disagree with that. I know for a fact that all will happen is they'll find another 13-year-old. Thank you.
Members, I ask you to vote no on the amendment.
The chair recognizes Ms. Garcia to close on the amendment.
Thank you, Mr. Speaker. Colleagues, you heard that a 13-year-old can do 10 years in prison for driving a car from point A to point B. And we also all know, because I know we have common sense, that that 13-year-old going to jail is not going to stop the bigger picture from finding another 13-year-old to do his bidding. So I ask that you please, please, vote yes for this amendment.
The question occurs on the adoption of the amendment. There's a record vote. The clerk ring the bell. Show Ms. Garcia voting aye, Mr. Guillen voting nay. Show Mr. Wilson voting nay. Mr. Patterson voting nay. Mr. Fraser voting nay. Have all members voted? There being 61 ayes and 84 nays, the amendment fails to adopt. The following amendment